legal research and analysis. The ability to conduct research thoroughly yet efficiently enhances a paralegal's value to the legal team. As a paralegal, you may be asked to perform a variety of research tasks. Some research tasks, such as locating and copying a court case, will be simple. Others will be more difficult and time-consuming and may take days or even weeks to complete. Many paralegals do research using computerized legal services, such as Westlaw, Lexis, and various online sources. But regardless of how you do your research, it's essential to know which sources to consult for various types of information. The text uses a hypothetical case, a lawsuit for negligence, to illustrate how to research case law. But before any paralegal begins to research case law in the hypothetical case, there are two preliminary steps to undertake. First is defining the issue. The first step in performing legal research is to identify the legal question or issue to be researched. Often, there's going to be more than one. In order to determine what the legal issue is, you must first examine the facts of the case. In this hypothetical case, the legal issue relates to the tort of negligence. Background research. If you're unfamiliar with a legal subject, you can do background research using a legal encyclopedia. Focus on the legal issues. Understanding the elements of the law, in this case the tort of negligence, will help you to determine the issue that needs to be researched. Identify the specific question or answer. Identify the specific question or questions to answer. Typically, there is more than one issue, and then research these issues. The second step is to determine the goal of the research project. You'll need to consider what types of sources you'll want to consult: case law, statutory law, constitutional law, administrative law, or other sources. Find cases on point. In researching case law, the goal is to find cases on point. These are cases involving factual circumstances and issues that are similar to the case before the court. Ideally, you want to find a case what's called on all fours. This is a case in which all four elements of the case, the parties, circumstances, legal issues, and remedies sought, are very similar. Another research goal is to find binding authorities, which consist of all legal authorities, statutes, regulations, constitutions, and cases that courts must follow in making their decisions. For a case to be binding authority, it must be on point and decided by a higher court, usually an appellate court. If a federal question is involved, the state courts will also be bound by the decisions of the U.S. Supreme Court. Cases on point from the highest court in your jurisdiction are what you want to search for because they carry the most weight. State courts generally have the final say on state law, and federal courts have the final say on federal. Some court opinions are published, while others, despite being readily available on the internet or in commercial databases such as Westlaw and Lexis, are unpublished. The distinction is an important one. A published decision is one that the court has issued and has declared to be binding precedent. An unpublished opinion might be cited, but is generally not binding precedent. It may be both persuasive to a court and some indication of how a court is likely to rule in the future, but again, it is not binding precedent. Opinions appearing in West's Federal Appendix Reporter are formally considered unpublished and are often not citable as precedent, but they do appear in a reporter to which lawyers and paralegals can cite. A persuasive authority is not binding on a court. In other words, a court is not required to follow that authority in making its decisions. Examples of persuasive authorities include persuasive precedents, which are previous court opinions from other jurisdictions, legal periodicals such as law reviews in which the issue at hand is discussed by legal scholars, encyclopedias summarizing legal principles or concepts relating to a particular issue. Often a court refers to persuasive authorities when deciding a case of first impression, which is a case involving an issue that has never been specifically addressed by the court. Research sources fall into the following two broad categories and may be located either in physical books or, more likely these days, online. First category is primary sources of law. These are court decisions, statutes enacted by legislative bodies, rules and regulations created by administrative agencies, presidential orders, and generally any documents that establish the law. Next is secondary sources. These are books and articles that index, summarize, systematize, compile, explain, and interpret the law. Legal research usually begins with the use of secondary sources, which is why secondary sources are also called finding tools, because they help us to find the law. American Jurisprudence, second edition, which is commonly referred to as American Jurisprudence 2D, or more briefly AmJur 2D, is an example of a major legal encyclopedia. Digests are produced by various publishers. They're helpful research tools because they provide indexes to case law. They arrange topics alphabetically and provide information to help you locate reference cases, but do not offer the detail found in legal encyclopedias. Let's talk about the West key number system. This divides all areas of American law into specific categories or topics arranged alphabetically. Topics are divided into specific subtopics designated by a key number, which is accompanied by the West key symbol. West publishes digests of both federal court opinions and state court opinions, as well as regional digests and digests that correspond with its reporters covering specialized areas such as bankruptcy. The American Law Reports, or ALR, and the American Law Reports Federal, ALR Federal, are published by West and are multi-volume sets that present the full text of selected cases in many areas of the law. They're helpful in finding cases from jurisdictions around the country with similar facts and legal issues. Treatises are formal scholarly works by a law professor or other legal professional that treats a particular subject systematically and in detail. Single-volume treatises that synthesize the basic principles of a given legal area are known as hornbooks. Some hornbooks, but not all, are available online, and they're useful to paralegals who want to familiarize themselves with a particular area of the law, such as torts or contracts. Each volume of Restatements of the Law contains a statement of the principles of law that are generally accepted by the courts or embodied in statutes, followed by a discussion of those principles. These are restatements in the areas of contracts, torts, agency, trust, property, restitution, security, judgments, and conflict of laws. Legal periodicals are journals that are published on a regular basis, such as law reviews and state bar journals. Written decisions of state appellate courts are published chronologically in volumes called reports or reporters, which are numbered consecutively. The reporters may be either official reporters, designated as such by the state legislature, or unofficial reporters published by West. Regional reporters are state court opinions that appear in regional units of West's national reporter system. To locate a case, you must know where to look. After a decision has been published, its standard citation is made up of 5 parts: case name, volume number, name of the book, page number, and year. When more than one reporter is cited for the same case, each reference is separated from the next citation by a comma. The most widely used guide for form is the Blue Book, a uniform system of citation published by the Harvard Law Review Association. An alternative guide is a booklet entitled ALWD Citation Manual, a professional system of citation, which is published by the Association of Legal Writing Directors. Paralegals should memorize the basic format and also check the rules of jurisdiction for guidelines on the proper format for citations in documents submitted to the court. Court decisions from the U.S. District Courts, which are the federal trial courts, are published in West's Federal Supplement. Opinions from the Courts of Appeals are reported in West's Federal Reporter. Both the Federal Reporter and the Federal Supplement incorporate decisions from specialized federal courts. West also publishes separate reporters, such as its Bankruptcy Reporter, that contain decisions in certain specialized fields under federal law. All of these reporters are published online. Opinions from the U.S. Supreme Court are published in several reporters, including the United States Reports, West's Supreme Court Reporter, the Lawyer's edition of Supreme Court Reports, and there's also free access to Supreme Court materials at the court's website and also at oyez.com, which is OYEZ.com. The official reporter of the U.S. Supreme Court decision is the United States Reports. Once you have located case law through your legal research, the next step is to analyze the case law and determine if it is applicable. Understanding the components of a case will help you simplify the task of reading and analyzing case law. The text provides a sample annotated court case with the important sections, terms, and phrases defined or explained in the margins. So while we're going through this, you may want to look at Exhibit 7.7, a sample court case, as we go through this lecture. Let's talk about the components of a case. First, you're going to see the case title. This indicates the names of the parties to the lawsuit. The V, of course, stands for versus or against. In a trial court, the plaintiff's name appears first. In appellate court, the names will sometimes be reversed. Next is case citation, which is found just above or below the case title. The citation number often appears at the tops of consecutive printed or online pages. The docket number immediately follows the case title. This is the number assigned by the clerk of court to the case when it is initially filed. A case published in a reporter should not be cited by its docket number, but the number may serve as a tool in obtaining background information on the case. Dates argued and decided. The date of decision usually follows the docket number. Sometimes the date that the case was argued before the court may be included. The syllabus is a brief summary or synopsis of the case, its facts, its issues, and the court's decision. In official reporters, the courts prepare the syllabi. In unofficial reporters, the publishers prepare the syllabi. Although the syllabus is helpful as a research tool, it's not a substitute for reading the case. Next is headnotes. Unofficial reporters often use headnotes, which are short paragraphs that summarize rules of law discussed in a case. In West reporters, they correspond to the West key number system. Names of counsel are usually the counsel representing the parties. Attorneys' names are usually found just under the syllabus in the headnotes. The name of the judge or justice who wrote the opinion is included, and in some cases, instead of the name of a judge or justice, the decision will be authored per curiam, or the Latin word for by the court, which means that the opinion is that of the whole court and not the opinion of any one judge or justice. The opinion of the court contains the analysis and decision of the judge or justices who heard and decided the case. Most opinions include a brief statement of the facts of the case, a summary of the legal issues raised by the facts, remedies sought by the parties, and in appellate court cases, the court summarizes the errors of the lower court, if any, and the impact of these errors on the case's outcome. Finally, the court's conclusion. In the opinion, the judges will indicate their decision on the issues before the court. When analyzing cases, the main focus should be on the opinion. This may require rereading the opinion several times. Look for guideposts in the opinion. Scan the guideposts, such as numbers, letters, or subtitles provided. Make sure they identify any dissenting or concurring opinions, and do not mistake those dissenting or concurring opinions for the majority opinion. Distinguish the court's holding from dicta. Determine which statements are legally binding and which are not. The holding, which is the legal principle to be drawn from the court's decision, it is binding. Dicta are other views expressed in the opinion, and they are not binding. When you're summarizing and briefing cases, it's important to summarize in your notes the important facts and issues in the case, as well as the court's decision or holding, and the reasoning the court used to make the decision. The components of the case brief that you want to make sure are in there are the citation, which includes both the case name and the full citation, the facts, which include reasons for the lawsuit, who did what to whom, and the identity and arguments of the plaintiff and the defendant. The procedure, to include the judicial history of the case, which courts it has been through, and what each court decided. The issues, the questions before the court, and the decision, the court's answer to the issue, yes or no, if possible. It's also important to include reasoning, which is a brief summary of the court's reasons for arriving at its decision, and the holding, the rule of law for which the case stands. The most common method of briefing cases involves the acronym IRAC, I-R-A-C. This refers to issue, rule, application, and conclusion. Decide what legal issues are involved in the case and include them in your brief. Determine the rule of law that applies to those issues. After identifying the applicable law, determine the application of the law to the facts of the case, and then draw a conclusion. Different lawyers and law offices have different preferences for the format used in briefing cases. Another primary source of law is statutory law. These are the statutes and ordinances enacted by legislative bodies like the U.S. Congress, state legislatures, and town governments. In some legal disputes, the constitutionality of a statute or government action may be at issue. So finding constitutional law can be important. Remember, the federal government and each of the 50 states have their own constitutions setting forth the powers, responsibilities, and limitations of the various branches of government. These are all available online. Statutes are often published in compilations referred to as codes, which arrange materials by topic. Most statutory codes are updated through the issuance of supplemental pocket parts or loose leaf services. Federal statutes are contained in the United States Code, or USC, and this is published every 6 years and updated annually. Sometimes they are known by popular name, a descriptive title, or the names of their sponsors. Refer to the popular name table to identify the official name of a statute. There are also unofficial versions of the U.S. Code. United States Code Annotated, or USCA, is the West version, contains the full text. United States Code Service, or USCS, contains references and citations to some sources, such as legal periodicals and the Legal Encyclopedia American Jurisprudence. Legal issues dealt with by attorneys are often governed by statutes and administrative regulations. Paralegals must understand how to interpret and analyze this body of law as well. There are 2 steps in statutory analysis. First, read the language of the statute and attempt to determine the reasons for the statute's enactment, the date it became effective, the class to which it applies, the conduct regulated by it, the circumstances in which the conduct is prohibited. Second, try to interpret the meaning of the statute. Researching statutory law also involves researching case law to see how the courts have interpreted and applied statutory provisions in the past. A statutory interpretation made by a higher court must be accepted as binding by lower courts in the same jurisdiction. Another technique used in statutory interpretation is learning the intent of the legislature. To learn the intent of the legislators who wrote a particular law, it is often necessary to investigate the legislative history of the statute. This can be done by researching such sources as committee reports, records of congressional hearings, and other proceedings. Congress frequently delegates authority to administrative agencies through enabling legislation. The orders, regulations, and decisions of such agencies are legally binding, and as such are primary sources of law. The Code of Federal Regulations, or CFR, is a government publication containing all federal administrative agency regulations. The CFR format follows the USC format, including the use of corresponding titles. Revised and republished 4 times a year, recent regulations appear in the Federal Register until they are incorporated in the CFR, and the online version is updated continuously. In summary, remember the first step in research is to identify the legal question or issue to be researched. When you're researching case law, the goal is to find cases that are on point and therefore binding authorities. Remember about primary and secondary sources of law. Primary include all documents that establish the law, and secondary are publications written about the law. The primary sources of case law are the cases themselves. Statutory and constitutional law are primary sources of law as well. Statutory law is often difficult to understand, so careful reading and rereading are often required to understand the meaning. Regulations issued by federal administrative agencies are also primary sources of law. I hope this lecture has been helpful to you in gaining an understanding of researching the law. Your assignment should be available on Blackboard. Have a great day.